Hello and welcome to the open platform of Public TV of Armenia. Today I will discuss the violation of international laws and conventions by Azerbaijan during the war against Nagorno-Karabakh in 2020, the cases against Azerbaijan brought by Armenia, and the return of Armenian prisoners of war. Mr. Yeghishe Kirakosyan, who is the representative of Armenia before the European Court of Human Rights, is at our studio today. Mr. Kirakosyan, thank you very much for joining us.
Thank you.
The European Court of Human Rights decided to notify the Committee of Ministers of Council of Europe on the issue of violations of rights of Armenian prisoners of war by Azerbaijan. Please give us some details. What is it about and what does it mean for Armenian side?
Yeah, sure. Actually, the Armenian side has been requesting the court to transfer the matter to the Committee of Ministers of Council of Europe for 3 months now, since December 2020, considering that Azerbaijan has failed to comply with the request by the court and the time limit set by the courts numerous times and repeatedly. And it has become a habit for Azerbaijan to violate the obligations under the convention and the requirements and the time limits by the court. So we, and also considering the sensitivity of the issues of the Armenian captives, including the POWs and civilian captives, meaning that we all know that in the atmosphere of racism and Armenophobia and ethnic hatred towards Armenians is highly, it's a high risk to the security of the persons of Armenian origin to be under the authority of Azerbaijan. So considering those factors, we repeatedly have been requesting the court to consider its competence under the Rule 39.2 of the Rules of the Court to transfer the matter to the Committee of Ministers. And luckily and fortunately, the court decided to do so just recently, a couple of days ago, and has notified the government officially about the decision taken by the court on 9th of March. And what does it mean for the country and for the issue in general? First of all, the Committee of Ministers is a political body of the Council of Europe, as opposed to the court, which is a legal body who is dealing with a legal dispute and trying as a legal mechanism, which has its own nuances and features as applied to any legal mechanism. And which, in this case, it's the proceedings before the court relating to the interim measures that has been requested by the government of Armenia are limited to written procedures, and which means that the government of Armenia sends the request, provides the evidence attached and annexed to the request with regard to the captives and POWs, and which is then communicated by the court to the Azerbaijani government. And the court sets a time limit and requires certain actions to be completed and certain information to be provided to the court. And in its turn, the Azerbaijani government is invited to do that in writing. So this procedure is quite a written procedure, not a very interactive one, which has its own disadvantages. And when we'll have the matter discussed by the Committee of Ministers as a political body, there you have all the member states represented in that body, where means that the issue of the captives becomes the agenda item for every member state, and that increases the attention towards that issue, and that increases the possibility of pressuring Azerbaijan. And that increases the possibility of asking questions and pressuring, and the Azerbaijani representatives, of course, will have to provide more detailed information, more detailed evidentiary materials, and justifications and reasonings for their actions or inactions. So this is the tool actually under the rules of the court, which is not very often used by the court. Let's put it in this way. And the court actually, my understanding was the court was reluctant from using this tool for quite a long time, because and also partly because that this situation that the court is dealing with in the aftermath of the 44-day war is quite unique. That's why maybe. This is the, in a nutshell, the answer to your question.
So it was a kind of a forced measure by the court. It waited until the red lines were crossed, and then it decided to apply to the committee, maybe.
Exactly. That was the case. I mean, the court waited until the old red lines were crossed. I think even more than that, because we're flagging the violations by Azerbaijan, I think, in every hour letter and every communication that I've been sending to the court, because the violations and the breaches of the court's requirements and the time limits have been numerous, and let alone not only that, but also unfortunately we witnessed also that after applying of an interim measure with regard to a certain person, unfortunately the person was found dead during the search operations around Hadrut, and which was unfortunate, which is a flagrant violation of the convention and the decisions by the court. So yeah, all the red lines were crossed, so the court had to do that.
Before I come to my next question, does Azerbaijan have any chance to violate this measure again? So after the Committee of Ministers is informed and the Council of Europe decides to, or other particular country decides to apply to Azerbaijan demanding to take actions, does Azerbaijan have any chances to break the rules again?
I think it will be harder, more difficult for Azerbaijan to, less room for them to maneuver, let's put it in this way. And I think in this case they will have less chance to manipulate with the court, which I think, I'm convinced that they have been trying to do at least. And we'll see. I think it seems to me that this is a more effective tool in terms of, this is the tool when the court is having recourse to when there is an issue with regard to the implementation of the actual or a certain decision or a judgment of the court. And the Committee of Ministers is the main body which is tasked especially with that specific task.
On February the 1st, your office announced about an interstate application against Azerbaijan with the European Court of Human Rights, claiming the convention violations during the war and after the war waged by Azerbaijan. What is the application about, and what stage are we now?
Sure. Indeed, this is a very major development in terms of legal proceedings initiated by the Republic of Armenia. And I think this is the first time that Armenia brings a case against any country. And of course, the violations committed by Azerbaijan during the war, during a 44-day war, and of course not only during but also in the aftermath after the war, and there has been numerous violations continuing to take place, unfortunately. This all created more than enough evidence to submit an application. And the volume of the violations committed by Azerbaijan is unprecedented, and this is even my understanding. The application, the interstate application, is submitted by the court under the convention, which provides the rights for the member states to do so in case of violation that happens, and that's the case. The court and the Armenia is availing itself with its right. And the scope of the application involves starting from the civilian victims, civilian wounded persons, due to indiscriminate attacks, due to targeted attacks against civilian infrastructure, civilian settlements, and civilians in general. And of course, it includes also the rights of the displaced people, which include, among others, the right to property, and includes right to private life, family life, which under Article 8, right to education, and there are many other. We have also a special group, the captives, whose rights also are being addressed in the application, the violations of their rights, meaning the rights under Article 2, right under Article 3, which are the right to life and prohibition of torture and inhuman treatment, rights under Article 5, the deprivation of liberty, and rights under Article 6, the fair trial guarantees. And also we included some portion relating to freedom of speech, and also which relates to journalists who have been performing their professional duties
during the war.
Yes, during the war, have been wounded and injured during the war, which was, and by the way, it included, among others, also international journalists.
Yes, sure. We the French media representatives, the Russians.
Exactly. Yes, yes. And this is so it's quite large, the scope. So yeah, it's we have been collecting evidentiary materials since the beginning of the war, of the hostilities in 27th of September, since the very first day until now. And this work continues. And recently, I was in Artsakh, in Stepanakert. I was meeting with counterparts there, and with the president, with the different ministers and different officials who are also working on the ground, who have gathered evidence or continue to gather evidence. Also, with their help, also we're creating this. We will be submitting additional supplements to the application that has already been filed.
In addition to what we have now against Azerbaijan?
Yes, we have filed the main application, but we will be filing supplements, we'll be filing new evidentiary materials, we'll be filing, because the scope is, as I said, is unprecedented. It is very large. It's and in this time frame, in the past couple of months, it's more. It's not enough. It's not enough for completing the whole evidentiary work. So it's evident that we'll need time, and in any case, we have done the first step, which is, I think, required by the proceedings under the Convention and by the courts. We have already submitted the application within the time frame, which is under the Convention, and that the Commission also allows us, and the rules of the court, and that will be allowed to file additional materials and evidence during the course. Yes.
Many media articles, reports, TV stories, radio, also reports by international organizations prove that Azerbaijan violated international laws and conventions you talked about. So what exact laws and what exact international conventions did Baku administration violate? Sure. Please.
Number. We're not speaking about only the European Commission on Human Rights and Fundamental Freedoms, which is the convention under which and based on which the court is operating, the European Court of Human Rights. But also, we should not forget that during the armed conflicts, an international armed conflict, the body of international humanitarian law is applicable. I mean, like international human rights provisions are applied in the context of the international humanitarian law, which includes the 4 Geneva Conventions of 1949. Those are the main sources which regulate the protection of rights and during the armed conflicts, including the civilians, the POWs, and also I will refer to Hague Conventions of 1899 and 1907, which are the main rules and customs of warfare, and which all of these are part and parcel of customary international law, which is a general international law applicable during the period of conflict. All this applies to Azerbaijan too. Now, Azerbaijan assumed and has obligations under the mentioned conventions and general international law. And of course, what happened during the war is very unfortunate. Of course, we have witnessed war crimes. We have witnessed which are prohibited under the Geneva Conventions, which included. If we start the means and methods of warfare, which are regulated under customary international law applicable to the conflict, which can include the targeting of civilians, settlement targeting of civilian objects and civilians in general, and that's a violation of IHL, humanitarian law. And of course, we witnessed, unfortunately, execution of captive persons. We have one of the very flagrant examples of that was execution in Hadrut of 2 captives, which is a war crime, which is a war crime under the Geneva Conventions, under the ICC statutes of the International Criminal Court. And we also had, I think, a number of examples of crimes against humanity, which included the persecution of the population, having the targeting.
Also the use of the banned weapons.
Of course, yes.
Chemicals.
The banned weapons, incendiary weapons of containing chemical elements, which are prohibited under customary IHL, and also the cluster munition, which is also prohibited under customary IHL, the prohibited methods of warfare when you are deliberately targeting civilian infrastructure, for example, or you are executing a POW or a civilian captive, or beheadings. Those are the heinous crimes, really very grave breaches of Geneva Conventions, which are unfortunately a practice that we have been witnessing since the April War of 2016. Even maybe if we go back to the first Artsakh War, we'll find examples of that too, unfortunately. And I think this is due to the culmination of the hatred in the country, and this which has been very meticulously and very in a systematic manner,
during the decades, previous decades. And also these torture and beheadings are characterized for the ISIS and other terrorist organizations by the international media, international experts. And I would like to explain to the viewers what other international platforms except the Human Rights Court exist to hold the Azerbaijani government, and also why not Turkish government, to hold them account for the war crimes and other hostilities they did during this 44-day war.
There are a number. I think the European Court of Human Rights is the main, I think, platform that where the Armenia is bringing its claims. And by the way, we have also received the application by the Azerbaijani government against the Armenian government, that also relating to same hostilities, and also it relates to some portions of the first Artsakh War, which is another topic of discussion, I guess. But there are a number of discussions and platforms that Armenia has the right to use, which I think I'll stop here. I think it's there, and including for holding accountable for international crimes or war crimes and crimes against humanity. Unfortunately, I think neither Armenia nor Azerbaijan are parties to the Rome Statute of the International Criminal Court, which is the permanent international criminal court established under the Rome Statute and started functioning since 2002. And this court is the main forum for bringing accountable persons who have been committed crimes against humanity, war crimes, genocide, aggression. And this is a forum that has the tools to be triggered too, of course, but Armenia is a signatory, but Armenia has not ratified the statute since the statute has been declared unconstitutional by the Constitutional Court back in the beginning of 2000s. But yeah, this is one of the examples. I don't want to go further any further, but there are many other possibilities under international law. We're aware of that.
Mr. Kirakosyan, thank you very much for joining us.
Thank you for the invitation.
This is Open Platform of Public TV of Armenia. Today I discussed with Mr. Yeghishe Kirakosyan, representative of Armenia before the International Court of Human Rights, and we discussed the violation of international laws and conventions by Azerbaijan in Nagorno-Karabakh conflict in 2020, the cases against Azerbaijan, and the return of Armenian POWs. Thank you for watching us.